Good afternoon. Welcome back. We are coming to the close of what has been a star-studded and enriching program. I'd like to welcome now and have the honor and privilege of introducing our moderator, our former Dean of the University of North Carolina School of Law and Professor Emeritus Jack Boger, and our panelists, which include Professor John A. Powell, Professor Kimberly J. Robinson, Professor Gerald Torres, and Professor Mark L. Tushnet. They will now discuss the ways forward in traversing the constitutional terrain. Professor Boger.
Thank you, Alan. We've been thinking for 2 days about one of America's most beguiling ideas, the promise, or at least the prospect, of full legal equality for all the people of the nation. It was a prospect that was declared, as we know, to be self-evident by Thomas Jefferson in the Declaration. Then some 90 years later, it was revived in the words of Abraham Lincoln's famous Gettysburg Address, something that he put into partial practice through the Emancipation Proclamation. And then, as Eric Snapper told us yesterday, in 1865, with the adoption of the 13th Amendment and the Freedmen's Bureau Bill, and then a year later, the Civil Rights Act of 1866, greater steps were taken. And then finally, express constitutional form in the 14th Amendment. In the Section 1, first clause, the clause Akhil Amar talked about yesterday, the Citizenship Clause, and then explicitly in the Equal Protection Clause, which forbade the states to deny to any person within its jurisdiction the equal protection of the law. Now, of course, we heard from Erwin Chemerinsky and Eric Foner how the 19th century Supreme Court proceeded to circumscribe the larger possibilities of this promise with a notoriously cynical reading of it. Then, as Jeffrey Stone and Michael Klarman talked and reminded us, the Warren Court in 1954 reclaimed a broader view of the clause, one which again expanded the possible reach of equality, and yet at least Boddy and Alsamudia James and Jerry Spahn quickly reminded us in their panel how the Berger and Rehnquist and Warren courts took a contrary tack, confining and narrowing the potential reach of the clause in matters involving race. Ted Shaw and Elise Boddy yesterday and Dean Mario Barnes today took aim at Justice Powell's infamous or famous opinion in Bakke, particularly contending that it provided a particularly injurious take on the obligations of the Constitution to work equal protection for all. And then the most two recent panels we've heard earlier this morning deliberately focused more closely in on the constitutionality of employing affirmative action and admissions in institutions of higher education. Now, though, our final panel can back up. We've been given the latitude to pull away from all that's come before, to look around what presently is in play, and most particularly to look ahead at the ways forward, what the future might bring. We are free, you panelists are free to talk predictively about what may come, subject on which Erwin Chemerinsky has already given us some sober caution in his opening remarks, as well as prescriptively about what you think ought to come. And there's a wonderful group of panelists assembled to have this discussion with an odd sort of tilt toward the latter end of the alphabet in their names. John Powell from the University of California at Berkeley, and Kimberly Robinson from the University of Virginia, Gerald Torres from Yale, Mark Tushnet from Harvard. Welcome to all of you fellow panelists, and thanks in advance to you all. Let me invite you, Kimberly, to open the conversation today by meditating a little on one of the present and the future subjects about which you've thought deeply and written so forcefully and well, the need for more equitable, higher quality education offered to young people of every racial and ethnic and socioeconomic and related backgrounds. Kimberly, the floor is yours.
Thank you very much. So first, I just want to say thank you so much for having me here, and how much I'm honored to be on a panel with these esteemed scholars, people who I've cited and looked up to for a long time. So I'm just really thrilled to be here. So I am going to talk about education, and particularly a federal right to education. And first, I want to just sort of set the playing field for what we're discussing. And so it's important to understand that in the United States, equal protection of the laws does not mean that we have equal education opportunity. Despite the language in Brown that it is a right which should be provided on equal terms, despite the pronouncements of the court, we have had really a very clear history of unequal opportunities along lines of race and a subjugation of the interests of people of color in obtaining a high quality education. And so what we see today is that the legal and policy landscape is really tilted against the success of children of color, of children who come from low-income households, and in many ways also children who are English language learners and children with disabilities. We are making progress on some of these issues, but we still have a very long way to go to really live up to the promise of equal protection of the laws. And so one of the challenges about that issue is that there's a disparity in understanding along lines of race about this gap and the existence of this gap. So just to give you one data point, there's a survey recently by Pathways in Education that asked people, do students of color get the same opportunities as their peers? Whites said 81%, yes. Children of color are getting the same opportunities as their peers. African Americans, less than half, 43%. Hispanics actually said 72% yes. And so what you see there is that there's a gap in knowledge about the opportunity gap. It is real, data confirms it, and I'll just give you a few data points about that. So if you look at a report from EdBill that talks about disparities in funding along lines of race, there's a $23 billion gap between white districts, that is districts that are 75% or more white, and non-white districts that are 75% or more children of color, even though they educate approximately the same number of students. So 23 billion. It's really important to just pause there and think about that, and think about what that means in the context of equal protection of the laws. We clearly, at the federal, state, and local levels, have failed to guarantee that the funding and opportunities for children are provided in a way that supports equal education opportunity and a high quality education for all children. If you look at other data about funding, you look at trust data, you find that over $1,300 or more is given, or more is given to white children than children of color. Same thing with poverty. We do not drive funding systems in a way that provides children from low-income households with the additional resources that they need. And more than half of the states, give either less funding to children in impoverished homes or the same funding to those households, despite longstanding research and consensus that children in low-income households need more resources. And we are simply not driving those resources to those children. So how did we get here? One of the things that it's important to understand is that the Supreme Court's interpretation of the Equal Protection Clause is in substantial part the cause of how we got here. So in the case of San Antonio Independent School District versus Rodriguez, which many law students graduate law school and they never hear about the case. They never read it, they haven't heard of it, and they don't study it. And so part of it is that there's a lack of knowledge about this case. So in a 5-4 decision in Rodriguez, the Supreme Court held that the Constitution does not protect a federal right to education, and that disparities in funding that along lines of class, although in the case, there were also disparities along lines of ethnicity, because the students who brought the case and their families were Hispanic Americans. The court said that there was not a fundamental right to education, and the court gave several reasons for that. It said that, one, it did not want to upset the balance of education federalism, and to basically have the federal courthouse be a place to litigate school funding systems. It said, no, we should leave this issue to the state legislatures for them to address it. In addition, the court said, we want to preserve and uphold the interest in local control of schools helps to encourage experimentation and innovation and investment in our local schools. And so the court also noted that they are not experts on school funding. And so they would leave those decisions to the experts, even though they acknowledge explicitly that there was substantial inequality and that should be addressed. They sort of urged the states to address it, but did not require them to. Well, fast forward, more than 4 decades later, and what we see is that there's been robust litigation at the state level. So some states did take up the call to address these issues. It takes entire classes to go through all of those cases. But the bottom line is we have made some progress in driving additional resources to children in poverty and sometimes children of color. However, we still have the funding gaps that I outlined at the beginning, which is along lines of race and class. We underfund children and we disadvantage them from the beginning. And then, of course, when you get to higher education and other places, they are coming in with a disadvantage that schools are then trying to left to address. And so the question is, what do we do about it? How do we think about this issue moving forward? One of the recommendations that I've put forward, along with many others, has been that Rodriguez should be overturned. That we should recognize a federal right to education that guarantees every child, equitable access to an excellent education. And I focus on equitable in part because children have disparate needs. We do not have the same needs in every household. And the decision in Rodriguez is one that, has within it possible grounds to overturn it, including the fact that the plaintiffs in that case did not bring an adequacy claim, did not bring a claim that children are not provided the education they need to exercise their First Amendment rights. And so what we see now in the courts is that litigators who are quite determined have returned to federal court and are beginning to litigate claims about the federal right to education. And so I believe that we will, speaking predictably, we will eventually see a case that seeks to recognize a federal right to education at the Supreme Court. I do not think that the current court would be willing to recognize such a right, but I do think that, shifts in justices, the death of a justice, anything of that nature could not easily, but could tilt us toward a court where you get, I shouldn't say easily about anything on this issue, but could tilt us toward a group of justices that would be willing to recognize the right to a federal right to education for every child. And so I can talk about those cases later in Q&A if we want to, but so I would say that is certainly one of the things that we need to think about, sort of prioritizing in our agenda for reform, and that is foundational to ensuring that children are equipped to be engaged citizens, to be self-supporting and productive workers, and also that it enables them to engage in the life of our nation. So with that, I will stop.
Well, thank you. You have given us a troubling look at evidence of continuing vast racial socioeconomic differences in K-12 education and suggested that needs to be addressed and has not been. I want to come back to that and talk about it at some length. But first, let's hear some opening remarks for other panelists. Mark Tushnet, we've reflected a lot in the last 2 days over efforts to establish or enlarge, or at least maintain equality using litigation. Should we be looking somewhere else than to the courts, federal or state?
Well, the short answer is yes, I think we should. I want to focus in my remarks on Congress in particular, and secondarily, for more complex reasons, state legislatures as the venues for promoting what I'll describe as a general equality agenda that includes, but is not limited to, issues of race. And I want to note that my view is that Congress in particular has been, if not not stellar in its promotion of an equality agenda. Probably overall a greater contributor to the promotion of equality across the board than the courts have been. Just want to note that in this, thinking about this, I regard statutes like the National Labor Relations Act as equality promoting, and the Employment Act of 1946 as equality promoting, with a footnote here that it was initially proposed as the full Employment Act of 1945, an issue that has now returned to the national political agenda. There are, of course, the various numerous civil rights acts that Congress has enacted, both in the voting rights area and in public accommodations and education, and notably, I think, in the Americans with Disabilities Act. I say notably because the Americans with Disabilities Act is clearly equality promoting and was something that the court was not about to do anything. Indeed, when confronted with the argument that persons with disabilities should be regarded as, in the doctrinal terms, a classification, the discrimination against which should be regarded as suspect, the court explicitly said no, it was not. So there's a substantial history of Congress, and again, I want to say secondarily, state legislatures promoting equality. Indeed, I think it's an interesting question whether net I call it now generally, the legislative contribution to the promotion of equality, including failures to promote and promotion of inequality, whether the net contribution of legislatures is positive, and then compare that to the net contribution of the courts. And my own view on this is that neither one comes out terrifically well, but I think there's a case to be made that overall, when you look at, let's say, a period since 1900, legislatures have enhanced equality and courts have, put it in the weakest form, not done so. To some extent have interfered with legislative efforts to enhance equality. And I want to turn to that next, that is the issue of the court's contributions. Because in this perspective, what I want to focus on is not the courts as promoters of equality, but courts as inhibitors of legislative efforts to promote equality. And we're all familiar with the relevant decisions here. They are recent in some sense, that is past 2 or 3 generations, but they are all, well, their foundations have not been eroded, let me put it that way. So City of Berkeley limits the ability of Congress to enforce its vision of what the 14th Amendment promotes. And my guess is that a City of Berkeley-like limitation would be imposed on congressional legislation promoting its vision of what the 15th Amendment seeks to promote. Shelby County, which invokes a non-textual limitation on congressional power, the equal sovereignty of the states, which I want to flag because the existence of, or the ability of the court to devise a non-textual limit means that when Congress is legislating, in some ways, it can't know what the court's going to say about what it's done. If they can make up a limitation in Shelby County, you can write your statute to do everything responsive to what the court said and still find yourself confronted with some other limitation. Let's see. In the area of affirmative action, they've told us that with respect to higher education, and I think with respect to everything else, there's a sell-by date of 2028. I wouldn't be surprised if the current court said, 2028, 2025, not a big deal, time to stop. And then finally, I want to note a sort of general phenomenon, which is in many of these areas, as Professor Robinson mentions explicitly, with respect to San Antonio and Rodriguez, federalism sort of in the large operates as a not quite legal constraint on what legislatures can do, but as part of the background culture against which what legislatures do is assessed. So as she was talking, I made a note here about her observation that litigation to establish a federal constitutional right to equitable education was reviving. My note was, well, imagine a congressional statute creating a legislated federal right to an equitable education, not tied to federal funding, a general right. I say not tied to federal funding because now, once again, we have the, I want to say, made up notion of coercive funding decisions coming out of the Obamacare case. And so I think in many areas, the court operates, as I said before, as a limit on the promotion of the equality agenda. Just before I conclude, I want to note that members of Congress, Democratic members of Congress, have now on the table 3 legislative proposals, H.R. 1, S1, and the John Lewis Voting Rights Restoration Act, all of which are clearly promotions of legislative efforts to promote equality, and I'm sure many portions of which would run into constitutional headwinds in the Supreme Court. Okay, so now just to wrap up, looking forward, what can we think about in this connection? Well, of course, we can always hope that if Congress does act, that in interesting and sometimes constitutionally unproblematic ways, the court will take that as a signal of disaffection with the doctrines that the courts have developed and pull back from them. So just to take an example, apply the congruence and proportionality test of Bernie with a much lighter hand than it might otherwise be applied with. For a variety of reasons associated in my mind with the way the composition of the court has been shaped by a sustained, just call it political campaign, I think that kind of retreat is unlikely. But the signaling idea is, I think, an important one. My view is, and Professor Robinson mentioned this almost under her breath, but I heard it, we have to keep the possibility of court reform on the table. Exactly what that form of reform would take is a matter for politicians, not for me as a legal scholar. We have to keep it on the table, both as a signal to the court of what I've called disaffection with the prospect of intervening against the quality agenda, but also as something that might be triggered in the event that the court, as I would put it, continues to pursue its campaign against legislative promotion of forms of equality that I think are important and essential for the future moral status of the United States. Thank you.
That's very, very rich. I want to get back and discuss that at some length. But first, Gerald Torres, we've got a suggestion. We need K-12 education reform, maybe coming someday from the court. We have a suggestion from Mark that we need a Congress that's protected against court intrusions or limitations. Any other sources of help for the equality agenda?
Well, I hesitate to suggest the executive, given our most recent experience with executive power. Nonetheless, I don't think it can be forgotten. One of the things I'll illustrate that in particular is, that's because I suppose most familiar with it, is the commitment to achieving equality and justice in environmental enforcement, and I'll talk about what that entails. But I did want to I'll start my comments in some ways by reflecting on what Professor Robinson, Professor Tushnet just said. Whether I actually make predictions, of course, is well, as Yogi Berra said, making predictions is always difficult, especially about the future. So I may stay my hand on that. Although, we are in a time that's complex, because there is, as Professor Tushnet noted, from the courts and from some political quarters, a retrenchment, but there's also a tremendous amount of ferment that is rooted in the desire for the promises of equality that are now several generations old. The promises from rooted in those promises and the desire to make them real. I think probably because we're in law schools, we tend to be court-centric, and so our enthusiasm or despair is often coupled with watching what courts do. But as Kimberly and Mark indicated, those aren't the only places to watch. Mark suggested a couple of things, and the legislature, and I think that we shouldn't underestimate the commitment to greater equality that many of our legislative leaders have. And there's another point, Mark mentioned it just in passing, but I want to underline it because I actually think it's important. And that is that we shouldn't be disheartened about legislative failures. So that even if we fail to accomplish some of the the robust changes in the direction of equality that some of our legislative leaders might want, it doesn't mean that the issue is forever foreclosed. Thomas Stoddard had I think an important article. I'm not sure how many people read it, but I think it's really important. And it's called Bleeding Hearts, and what it was about. It was about the process of reform, anti-discrimination reform that was run by and organized by the LGBTQ community. And what he does in his essays, he details 15 years of local legislative failure, of promoting propositions, promoting amendments, promoting ordinances, and never succeeding. And finally, he got so frustrated, he said, I've got to take a break from this. And so he searched the world for the area that had the most gay-friendly laws on the books. And he went. And he said he went and anticipated there would be some kind of respite, if not an actual paradise. He said, and he got there and he realized it was like 1950 in New York City. He went to New Zealand. And that's when he said, the prospect for gay equality in New York is actually much higher, despite all the failures, because the conversation, the political struggle actually prepares the ground for the change. And so even where we have legislative failures, having the public discussion about equality, and here we're talking primarily about racial equality, but having the public discussion about equality, in fact, changes the baseline or can change the baseline. And what Professor Stoddard said is that you don't get real change unless you couple cultural change and legal change, or rule change and cultural change. And that's what the defeats help do. So that we shouldn't look at things that feel like failures. And I'm not going to suggest they don't feel like failures when we don't succeed. But it's not a final failure, and it can actually be a slight move forward. So that the efforts to reform the Voting Rights Act, as Professor Tushnet mentioned, is absolutely critical. Absolutely critical. Having the fight about just representation, having the fight about making the polls available to all voters is a fight worth having, even if we don't succeed in getting the legislation passed. It's a fight worth having because talking about what the way a democracy is supposed to function at the federal level, but especially at the state level, and I agree with Mark on that, especially at the state level, is absolutely critical. I want to underline a point that Kimberly made, because it's really critical, both about democracy and about education, and understanding the nature of public choices that people make. So when Proposition 209 was passed in California, that was the proposition that banned affirmative action in California. People were reacting, both because of the narrative about race, but also because of the perceived lack of opportunity for their children to get higher education. When Lonnie and I were doing research about this years, my good friend Lonnie Guinier and I were doing research about this years ago, what we discovered was the year running up to the to Proposition 209 being on the ballot was the year that California spent more money on all lockups, county through prisons, than on all education K through 16. Wow. So California had made a public choice about where it was going to spend its money. It made a choice about what kind of institutions would be available to its youth, and it chose prisons. It chose jails. It could have chosen schools. So that, in fact, people were feeling a constraint an educational opportunity, but they were blaming the wrong people for that constraint. It wasn't because Black and brown kids were going to college. It's because the state had stopped investing in public education. We need to make that visible, and we need to talk about it critically. One other example, then I'll talk about the executive. I forgot how much time I have. I'm probably already exceeded it.
A couple more minutes.
A couple more minutes. Okay, so the Texas, right? You talked about Rodriguez. Well, Texas has a state obligation to equalize education. Maldef there is arguing that equal means equal, right? So and they've been fighting this down the road. But what it did do is it created the opportunity for us to pass the 10% plan, which essentially opened up higher education for all graduates of public high schools in the top 10% of the class, meaning that Texas could enroll more Black and brown students, University of Texas, more Black and brown students than they did under affirmative action. And this is critical, the students at the University of Texas who have succeeded, measured by GPA and graduation, are Black girls who have been enrolled under the 10% plan. What it told the admissions officers is they thought they knew how to construct a class. There was so much about the students who could make use of a university education that they didn't know, and they'd better learn. So that's critical. So let me talk about affirmative action and executive action in about 2 minutes. One of the most gratifying things for me is to hear the word environmental justice come out of the mouth of a president of the United States. With his executive order, what President Biden has done is he's instructed the Attorney General to put an emphasis on environmental justice in the Environment and Natural Resources Division. What that can mean, of course, is taking affirmative litigation under Title VI, using the tools available to the executive to actually get more equality, and in fact, using the Environment Division to help teach the other divisions about how to get equality and how to use the laws of the United States. The president has instructed the Department of Justice to make this a priority. How they do it, of course, is going to be up to them. We have a different president, right? But the executive can also instruct his agencies. And the power of the executive to actually chart the direction should not be underestimated. One thing we've noticed, or one thing I think we should have noticed, is that good leadership is actually almost invisible. Bad leadership, you can't get away from. And so even if you don't see major initiatives, but you have an executive that's committed to these values, I think we're going to need to dig deep to see where those changes are made. But you don't miss leadership until you don't have it. I think we have it, and I think we have it in a commitment to greater equality. I think the statutes that are proposed that Mark mentioned are important, whether they succeed or not. I think they have to succeed, but even if they don't, the education is important. And I'd be happy to talk about any of these issues in greater depth. The question and answer.
I hope we talk about all of them. Indeed, John Powell, thank you. John, to oversimplify what we've heard from these first three opening remarks, there's a prospect for litigation. There's some prospects in Congress. There could be some prospects in the executive branch. But as Gerald was really lamenting, and I know you've written a lot about, there's seemingly unbridgeable gaps in the culture, in the politics, in Congress, in the courts. And it almost looks as if none of those things can be overcome without a reforming of our public culture and values. What are your thoughts on whether that's necessary, and if so, how, and does it precede or go along with the initiatives that you've heard talked about? You've got to unmute, John.
So you should have heard me. I was really eloquent. So
I bet that was the highlight.
No, I just want to thank you and the law school, but also it's great to be with this esteemed set of legal scholars and activists. I think it's iterative. You know, things actually don't move sequentially. They move back and forth. And Gerald talked about the cultural piece of this work. I think Kimberly talked about the court. I mean, sometimes we talk about the law as if it's a thing independent of who's actually promoting it, interpreting it. That's huge. Rodriguez, we lost 5-4. Parents involved. I mean, one justice, and we'd be in a very, very different conversation. And it's been basically the strategy and the capacity of the right wing to actually use the court to do what Mark is talking about in terms of constraining equality. I mean, starting with the slaughterhouse case. I mean, even the Civil War amendments weren't even dry, and the courts radically constraining the concept of equality, and basically saying it's possible that the Congress wanted to go this far. We couldn't mean that. That would be a radical change in the country. Right after we've had, at the time, the worst war in the history of humankind. And that the court's going back to some kind of a narrow sense of federalism. So I think it has to happen on multiple levels. And I think the law is not just a coercive thing, it's actually part of the culture. It's the way we talk. So everyone talks about the First Amendment, no one's read it. Free speech, but it's like, Second Amendment, probably even worse, right? I wanted to start by doing a couple of things. So Jack, when we talked, you said, you want me to sort of, in a sense, help with some conceptual and philosophical grounding. And I'm going to take you up on that. And then I'm talk about what that means in terms of where we are and where we're going. So it's interesting. Kimberly talked about equity, not equality. She talked more about equity. And why is that? Part of it is that we have this history of this very narrow concept of equality that doesn't really serve us. And so we shifted from talking about equality to talking about equity. And in the school context, some of you know that we actually shifted again to talk about adequacy. And I talk about that in the context of target universalism, which I won't go into because of time. But the shift from equality to equity seems like, and I was involved in that shift in the 90s. And it seems like, progressive things that, some legal scholars and others, school activists, pushed to redefine equality. But actually, when we look at it more carefully, it's actually going back to the original concept of equality as it came to the West. The concept of equality in Western society really comes from Aristotle. And Aristotle understood that there's different kinds of equality. And he said, fairness requires, in terms of equality, that when people are situated the same, you treat them the same under equality. But fairness also requires when people are situated differently, you treat them differently under equality. That's something that Kimberly, Gerald, Mark, you, Jack, we'd all embrace. That's Aristotle. So we end up taking this very narrow concept or supposing that everybody's situated the same so we can treat everybody the same. It's like, well, no, that's not true. Everybody's not situated the same. And we know they're not situated the same because we situated them. We put Black kids into segregated neighborhoods without adequate resources. We know they're not situated the same. It's not hypothetical. But where we are now, and I think about, first of all, we have new leadership. President Joe Biden is the first president that talked about white supremacy in an inaugural address. He may have been the first president to talk about it, period, in public, but certainly in an inaugural address. So what we're dealing with is something more insidious than the right definition of the 14th Amendment. What we're dealing with is a structural hierarchy along racial and other lines. Isabel Wilkinson basically says we're dealing with a caste system, as does Michelle Alexander. But we're dealing with something that takes us beyond the sort of technical understanding. And I think it's important for us, law students and the legal profession, to understand that. And I think Trump, frankly, understood that. And the reason that President Biden can talk about white supremacy is because Trump practiced white supremacy in blatant terms. So one of the issues, Jack, we talked about in preparing for this panel, there was a school district that came to us and they said, we are being sued because we're teaching students about white supremacy and how to oppose it. And the plaintiffs are saying, we're teaching people to hate white people and to hate America. And as you know, under the Trump administration, they had a rule saying you couldn't teach critical race theory was associated with hating white people and hating America. So Gerald, you're responsible for this executive order coming from the Trump administration. And groups all across the country were calling in panic. What are we going to do? They're saying we got to stop teaching implicit bias. We got to stop teaching critical race theory. We got to stop teaching. And this is sort of what the court does. It has this narrow definition of what's permissible and what's not permissible. And what it does in terms of what's permissible leaves us in a box that won't allow us to get to where we need to get to. So Biden comes in, he rescinds that order, and instead says, we're going to address white supremacy. So when the school was, before Biden came in though, when the school reached out to us, the school district reached out to us and said, what do we do? Do we stop teaching about white supremacy? We're afraid, we don't want to be sued. We're not lawyers. And what I suggested to them, that I would look at the material and help them think about it, but that really what they were challenging was the concept of supremacy and domination. And the white part was just one expression of that. But to really assert that in terms of an American education and American core values, what's challenged is domination and supremacy writ large. And I said, you can, if you argue that, and then say, we're going to look at white supremacy because that's a prominent expression of that at this time in history, and maybe prior history as well. But then you're on solid ground. Then you're associating yourself with Lincoln. Then you're associating yourself with the Declaration of Independence. Then you're associating yourself with the Gettysburg Address. Then you're associating yourself with Justice Harlan. Then you're associating yourself with Loving. And so part of what I think is happening is that we have to reframe what's happening, because there's a sense in the country that some groups of conservative whites are deliberately and explicitly holding on to the notion of dominance. If you go back and look at the literature, and 20 years ago, only 5% of white Americans would have said their white identity was important in terms of who they were. And most of them rejected the notion of dominance. Today, that number is close to 40%. And in that expression of importance of white identity, there's also a corollary where people are re-embracing the notion of white dominance. And they frame it like whether it's Christian dominance or Western dominance, but a belief in dominance. And so to me, it's sort of interesting because I live in California, there's no racial majority here. It's also true in Hawaii, and I know Texas is not far behind us. And so as the numbers change, as the possibility change, the issue becomes more salient. And if we go back to Plessy just for a minute, one of the things that Homer Plessy argued was that he was part 7/8 part of the dominant race. And that, and this is Cheryl Harris, his whiteness was being taken away from him without due process. He was losing his the privilege and association of being part of the dominant class. And the majority talked about the dominant class and what would happen if whites were no longer the dominant class. And then Harlan, in his dissent, which is oftentimes misinterpreted because of the colorblind expression, he says, whites believe they are the dominant class, and they are in terms of skills, intelligence, and other things. But in the context of law, there is no dominant class. The law does not recognize a dominant class. So what I want to suggest is that Harlan is associating himself with that school district. And the fight going forward is to actually embrace that notion that there's no dominant or superior class, and it's constitutionalized. It's not just an idea. And that the practices we're engaging in should be reformulated. So segregation is an expression of dominance. And the courts acknowledge that. The kind of racial hierarchy, and that we have an affirmative, not just a reactive, an affirmative role to actually promote a kind of society where there is no dominance. Now, it's tricky in the sense that a lot of people who challenge white dominance or white superiority implicitly insert an alternative dominance. So some of the stuff talks about a new racial majority, right? The underlying assumption, and certainly underlying fear, is that if people of color becomes the majority, whites will be dominated. And the Trumpsters can play on that. And I think we have to be clear, that's not what we're talking about. We're talking about a society where there is no dominance, but we're also learning from Aristotle that groups are situated differently. So it doesn't mean treating everybody the same. So if you think about Powell in his terrible, terrible decision in Baki, in some ways he prefigured this fight when he says, there is no dominant group. Everybody's a minority.
You're not arguing it's white innocence. He may be done it, but you're saying we can turn that back around.
Right, exactly. And I'm saying, I think you're going to see even conservatives on the court, and they're not real conservatives, but right wings on the court, really struggling with this issue. And going back to Mark's point, is so as people of color, as progressives actually assert themselves legislatively, the court will have to maybe in a position of either going along with it to help reform or stopping it more and more, and at some point triggering something that actually reformulates the court. So I think part of the way forward is to make it clear that we are, that this impulse of not having a dominant culture, a dominant race, some people will reject that. And they say, clearly whites were a dominant race. Look at all the laws that were passed, look at the immigration bills, yes, but that's the struggle that we both, and that's what Lincoln was talking about in the Gettysburg Address, which was controversial. The Chicago major newspaper wrote a scathing review of the Gettysburg Address for two reasons. One, they're saying the Civil War is not about equality. What's Lincoln talking about? What's he been smoking? I mean, it was scathing. And secondly, he skipped over the Constitution and went to the Declaration of Independence as our most sacred founding document, because the Constitution had enshrined slavery, even though I didn't mention it, and rejected any notion of equality. So that fight continues to go on. And I think it's a good fight to have. And we can ground it in terms of our history. And again, maybe begin to move beyond dominance, but recognizing that people are not situated.
Let me intervene to do three things. There are three things I want to do. I want to talk at some point about the prospects for education as one of the things we discussed. I want to talk about the role of the legislative branches, but I want to invite the panelists to get back and engage John on the question of whether we are at some kind of historically special critical moment, and whether this kind of notion of a different sense of equality is a prospect that's real, or something you can do when you're at Berkeley sitting in your room. What's your responses to it? Anybody?
I think the possibility of having a class-inflected discussion is actually great. greater now than it's been in a while. The direct confrontation with white supremacy will also have to occur, and it'll occur at all levels. You know, the polite level, the level we see, you know, some of us have experienced, but a little, you know, and ultimately, I think we will prevail in that struggle, but it will be a struggle.
Other thoughts, Kimberly?
I think we have an opportunity actually here with this, particularly with the younger generations. So we have 3 daughters, and I can tell you the education they are getting about this moment, right? So this reckoning of race and inequality and injustice, they're getting this message at a much younger age. The students I have are much more awake to this moment, and they see that there is a problem, that, you know, a cancer really in society, white supremacy, that we have to reckon with, and we have to deal, we have to be dismantle. And what I teach my students and our daughters is that you have to be as relentless in removing, ending, uprooting, eliminating injustice and white supremacy in the same way that segregationists and white supremacists have been relentless, right? So the problem we've run into with the court is it has this very short memory. It fatigues on school desegregation. Oh, okay, we're about done. They tried really hard. We're going to release everybody. You know, you get these very short, you know, the fact that Shelby County went the way it did, same thing, this short memory. But we have a much longer history of injustice and oppression than we're just at the tip of the iceberg of starting to address it. And this, you know, collective forgetting of slavery and Jim Crow and the long reach that it has, I think is something that this current generation, if we seize this moment, can help to address. Because without that understanding of the history, you need that understanding, that correct understanding and accurate understanding to get to a place where we can say that the Constitution does not enshrine a dominant race. But you have to reckon with that history before you can get to the equality promoting conversations. And there's a way now, and even in class with students, they understand the race issue more than a decade ago. And so I think we have to seize this moment to say, we must be relentless about this, or else we will not prevail.
You know, you as Mark.
I was going to say, Jack, you know, in your state,
yeah,
right, you have the historical moment that was called fusion politics.
Yes.
And you have Reverend Barber.
Yeah.
And you have Penda Hare.
Yes.
Down there doing work in North Carolina, trying to revive fusion politics. So movements like Forward Justice in North Carolina are the kinds of things that give me hope.
That they certainly do in that regard. I must say, I was just personalizing what you all were saying in terms of in a sense, you've got the hardest task of any of the panels, because the other panels simply talk about the past and the present. You've got to talk about what might come and how it might come, and that is always harder. I will tell you, just when we thought about this conference, this symposium last year, Ted and Alan and April and I sort of said to ourselves, well, you know, it could be that the administration changes and there's a new administration, and that would make it a more interesting symposium. And it could be that, of course, we'll have court opportunities because there are older people on the court and some of them will be leaving, and we'll be able to replace those. But there's no real prospect that the Senate or House will turn over. Likely the House will stay Democratic. And almost every one of those things is worked out in a way that creates some opportunities and forecloses others. You know, Mark, you were very powerful on the negative role that a court can play in restraining Congress and any other branch, the executive branches as well. And so we are at a place where both your conversations and prospects are available that are different than one might have guessed even 7 or 8 or 9 months ago. But
Jack, let me just add 2 things because and bring it to some practical implications. So I think there is a realignment, and I think part of what I'm suggesting is that we oftentimes on issues of race in particular have a zero-sum approach. One group wins, another group loses. That's how we structure affirmative action. That's how people think about affirmative action, and sometimes we fall into that. And I have a lot to say on that, but I won't right now. So we have a sort of false scarcity and a feeding game. It's like, who's going to win? So white rurals are going to win, or urban blacks are going to win, or Latino. And it's like, we have to actually have something different. And I would love to see a lawsuit, maybe in California, building on what Gerald talked about. It's like the state has imposed false scarcity on the number of students who can go to schools by building prisons instead of schools. And then the students who are more than qualified to go and succeed, as they are in Texas, are left fighting over the few chairs in school. And then it becomes racialized. So why hasn't someone sued the state for imposing this false scarcity on the student body? And to do it in a way that doesn't pit Black students against Latino students, against white students, against gay students. So that's the other piece. It's like the false scarcity actually makes everything harder. And the last thing I'll say on that, so you see Trump when he was saying about the affirmative furthering fair housing, right? Saying they're coming to get you. They're coming to your neighborhood. You better watch out. Or we also see General Motors and several car companies going back to the environment saying, okay, we're capitalists. Yes, we are, but we don't hate the environment. We need to make money. But if we can figure out how to do that, we'll work with you. So I think there can be a realignment of identities, a realignment of interests, but it does take leadership. And it does take a notion that at the end of the day, we all will belong and no one group will dominate, which is as old as the country itself.
let me ask you, though, to concretize it, and you were talking about that, going back really to Kimberly. Kimberly's proposed a major effort in the area of K-12 education, as I understand it, to, in a way, a Brown versus Board notion that education is foundational to all other possibilities in society. If we did a plebiscite of the four of you right there, and you can't do everything at once, although different people can do different things, do you think that's a good place to spend the next 2 or 3 years with some emphasis, maybe at the state level, but also federal congressional statute that says, by God, let's have equality in K-12 education? Is that a good concrete place to focus attention?
Well, I'll jump in here with the qualification that what I'm about to offer is a political analysis, and I'm not a political scientist. I'm just an ordinary observer of politics. My specialty is not in stuff I'm about to say. So my own view is that, first of all, I agree with John Powell that leadership is essential. I think that for a complex of reasons, dealing with the, call it, demographic transformation of the United States, an important component, and for me, the most important component of an overall equality agenda is economic opportunity. And so I think a focus on jobs and infrastructure and Green New Deal kinds of jobs is, for me, would have priority over want to say large targeted investments in education alone. Now, the reason for that focus is political. It is, on my own view, again, speaking as an ordinary citizen, not from any specialty, that the primary difficulty facing the accomplishment of the racial equality agenda is the successful effort by, again, political observation, by Republican Party leaders to displace economic anxieties among people who have been left behind by the essentially white working class people who have been left behind, to displace those economic anxieties into racial anxieties. And if that analysis is right, then the way to combat the racial anxiety is to reduce the economic anxiety. So that's my story. I think it's right, but could be wrong.
Responses?
So I think,
Go ahead, Kimberly. I'll wait.
it is really important that we address the need to expand employment opportunities in many ways, particularly for those within the working class. I guess my concern, if it was going to be a focus, although I'll just challenge the question a bit, Jack, which is that I think that short-term focus that you said, 2 to 3 years, of course, would be quite short for being successful in any of these efforts. To build upon what Mark said, my concern with the shift to jobs and employment is that you would solidify the disparities in educational opportunity. So who would be qualified for which jobs would merely mirror the inequality that we have tolerated, or not just tolerated, but invited, encouraged, continued for generations. And so I do think we need to expand employment opportunities, and I think you could do that at the same time as education. But I think if you don't give some priority to education, you'll merely reinforce the inequalities that we already see. However, in terms of priorities, I did want to clarify, actually, I completely agree with Mark that Congress should be the one to act on education. It's preferable. I knew that he would speak about Congress. I focused a bit on the court because often that's where we start. But actually in my book, A Federal Right to Education, in addition to the introduction and conclusion, I write the chapter about Congress recognizing such a right. And so he and I are actually in agreement that it is preferable for Congress to recognize the right. The court is not the preferred branch to do this. So I just wanted to also note that point.
Why don't you, for the benefit of the audience and the other panelists, do a little bit of a sketch about what you'd see happening there in Congress toward creating a federal right? It was a very interesting proposal you had in your book.
Sure, yeah, I can sketch that out. So the proposal is that Congress would, in recognizing a federal right to education, would first, I think one of the difficulties with recognizing a federal right to education is that there's disagreement about the content of the right. So for decades, there's been a suggestion that Rodriguez should be overturned or that we should have a federal right to education, but there's not agreement about the content of that right. And so what I propose in the book is to have kind of a series of legislative actions that would begin to test models for a right to education. In other words, we don't have the perfect language at this point. And so part of what I suggest in the book is to examine some possibilities for definition for a right to education that then would be ultimately enacted. So sort of having the kind of experimental programs we've had in education for quite some time at a small scale, not, one of the reasons No Child Left Behind was criticized so much is that we made this national change all at once instead of having more of a smaller sort of experimental program. So part of what I say is, I think we need some experimentation around what the federal definition should be before we say that it should be imposed for everyone, because what you don't want are some unintended negative externalities for opening up that issue. And then I also proposed in that chapter much more of a collaborative enforcement model than a litigation-based model. So again, I don't want to hand a right that's created by Congress over to the courts. What I would want is for there to be a collaborative model in which the federal government, in making demands about education, also partners with states to support them through not just financial assistance, but technical assistance and other assistance to achieve the ends of protecting this federal right to education. So that is what I detail in the book. I'll actually put the book in the chat, and as well as a discount code for the book, because it came out not that long ago. Slight minor plug of my work. But I do think that it is a preferable path forward to the court. And I think there are real drawbacks to handing over a federal right to education to the court. However, as between the court and no federal right to education, I think that the court would be preferable to not having a right at all.
If I could link Mark's idea with Kimberly's idea, right? One of the jobs programs would be building schools. Right? When the Godinez case was litigated in LA, the number of kids without a desk in the Los Angeles Unified School District would have been the 5th largest school district in the United States.
Wow.
Okay. That's just the kids without a place to sit down. Right? Until they have a place where they can learn, the right can't be, I'm not going to say it's empty, but it can't be as full as it should be. So, the building trades is one place we ought to look. I think what Mark suggested is focusing on some of the economic impediments that our country faces and that working people face is actually really critical.
Let me
Please, John.
add sort of a note of caution. I mean, I feel like the issue of race and class is as old as race and class in the United States. And I think it's a mistake, frankly, to simply, in a categorical way, assume one can precede the other. What race and, Paul Krugman basically said, you can't understand the economy in the United States without understanding race. And I feel like that's the mistake that we make. We think they're separate. They're not. They're incredibly interactive. And so I would caution against, and yes, the Republicans have used, although before 1960 was the Democrats. And one question that Derek Bell asked is, why does it work so well? We've been saying, yes, they're sort of using this to deflect us from, but why does it work so well? So I think we have to, from my perspective, not treat race just as a rule that's sort of used. It does have some meaning to it. Robert Sapolsky in his book, Behave, he talks about, if looking at wars, he said most wars were started over what he called sacred symbols. So I think, again, I'm not saying economy is unimportant, but I would avoid stepping into that pitfall of either or. Ian Henry Lopez, a colleague, has written a book called Merge Left, trying to show how you sort of think about race and class together. But I think that's the way forward, not just one or the other.
One of the issues, though, that John raised, I think everyone raised in one way, is the issue of white supremacy and how you start to dismantle it. Right, when you think back to the woman who called the cops on the bird watcher in Central Park, right, and in some ways people treated that like a crude but not as important an event as it was. The critical part of that story, it seems to me, And it's one of the ways that white supremacy is operationalized. Is the woman who called the cops knew what she had to do to start the entire machinery that would discipline the fellow that she was angry at, right? That to me is the story that should have come out of that encounter. That the dialing 3 numbers on your phone would start the social machinery that would result in the racial oppression of this fellow, right? It's pure and simple, right? And even though she may not have been a racist or thought of herself as a racist, she knew how social institutions would do the work for her. And what we have to start to do is to disable that capacity.
And you're going to follow up with a suggestion on how.
I defer to Yogi Berra.
Yeah. You know, my thought, Mark, about what you said is I see the power of the focus on improving everybody's economic circumstances through jobs and infrastructure. My uneasiness is we've tried some efforts like that in the past and haven't taken race into account and found that we have structured further sort of racial disparities into whatever it was, whether it was urban renewal or other kinds of, kind of investments that further marginalize some people based on their race. And so in a way, I'm arguing against the question I ask, which is which do you make the preference for? And John, I'm echoing what you said. You can't not make it about both things, or at least race, whenever you're doing whatever else you're proposing to do as a first priority.
So I agree with that and with John's observation. Again, my view is that over the past 20 or 30 years, the Democratic Party leadership has in fact not focused on the two things at once. And what's encouraging about the current moment is precisely the kinds of things that were referred to when, I now forget whether it was Gerald or John, mentioned Biden's inaugural address, where I'm confident that it's the first time that a president has, in a prominent place at least, uttered the words. And these executive orders are an indication of the attention that, because of political considerations, I don't want to say this is, it is partly the goodness of his heart, but it's also because of the political moment. It's important for Democrats now to visibly commit to both agendas simultaneously in a way that I don't think it had been since, I'll say since Bill Clinton. The era of big government is over. I mean, that was a signal about who the Democratic Party leadership was responsive to, and it wasn't the African-American community. Biden is, again, is a political observation, but he's different. And, despite the narrowness of the margins and the uncertainty of the political moment, I find it I am strikingly encouraged by the dual focus that the current administration appears to have. Whether they can sustain that under, over time as politics plays out, who knows? But they're, in my view, doing better at the starting gate than I would have expected.
So you're a surprised optimist in some respect.
Yes, I am.
Others on that span of where we are now, are we at a time of, reframe the question, of great prospects or great precarity, or maybe both at the same time? Very narrow margins in the Congress, a court that could do a lot of negative restriction and restraining, and it could overturn higher education, affirmative action. It could reject any voting rights advance under the John Lewis Act or whatever. It could start getting serious about the non-delegation doctrine and restrain executive action. Where are you? Gerald, do you want to make a...
Well, about, I hate to say this because it just marks out how old I am, right? But in the 90s, right, I remarked to someone about some district court opinions that were reviving the non-delegation doctrine. And I said, we've got to pay attention to this, guys. And they said, oh, some district court will always say something stupid. Something is what basically dismissed me. Well, we should have paid attention. Should have paid attention. The struggle, and I think, like Mark, I'm talking as a non-expert, as just an ordinary observer about politics, but it's going to play out on a variety of fronts. Some of it will appear to be, technical. And so we've got to be, ready for kind of the technical changes, as well as the more kind of in-your-face changes. I think Mark, my other panelists, I'm not going to single anyone out because I think they're all in agreement, and probably Jack, you are too, right? I think the moment we're in requires us to make the kind of broad-gauged policy proposals that encompass all of the people who responded to get 2 Democratic senators from Georgia and Joe Biden elected president. And people have got to work assiduously, carefully, and honestly every single day on that, because the margins are thin, but we are in a moment where actual progress can be made. And I think Mark's right on that. I think John's right on that. And Kimberly, if we can get a right to education, we can start to talk frankly about what that means, piece by piece, right? And it doesn't have to happen all at once, but it has the trajectory, right? It has to start moving in that direction. And I guess that's what I would say. And that's why I think Mark's emphasis on the local and the state remains important. I mean, that story I started with about bleeding hearts and changes on discrimination against LGBT groups in New York, that's a local story. Now it's New York City, but it's a local story, right? And so, work at the local level actually matters and will continue to matter.
We're talking to an audience that's got a lot of younger people in it. And one of the romances of when you go to law school is that you read Plessy and then 2 days later you read Brown versus Board and you say, I want to be one of those people that files that lawsuit and changes everything, although they don't yet know that Brown didn't begin to change everything, and other decisions like that. I hear you in effect giving a counsel to young people, although I don't put words in your mouth, that are now 25 and have a 40-year, 50-year professional life ahead of them, that there's lots of opportunity at the local level and not with necessarily grandiose, immediate change that will accomplish everything. Is that a fair?
I think that if you're paraphrasing what I said, I think that's fair. I mean, what Kimberly said earlier is really true too. When I talk to my kids and their friends, now admittedly, they're my kids and the friends of my kids, so I'm getting a skewed perspective, I'm sure, right? But they see a world that is so different than the world that those people who stormed the Capitol see, right? And that's the world we have to be hopeful for, right? The world that they see, the world that they want to build and inhabit, that's the world I want to put my money on.
How do we get those folks?
Well, you get them doing, you know, when I worked for the Children's Defense Fund, right, we would go to Mississippi, and Marion Edelman, who is a genius and prophetic, right, said, you know, you go down there, you're going to litigate, but in the evening you're going to organize, right? So that we're not going to parachute in from Washington D.C. and leave. We're going to go down there, litigate the cases, and then you're going to build a community that can enforce the decree if we win, right? And so she understood that you had to build a political infrastructure, and that lawyers were part of that task, but they weren't, you know, the knights riding in on white horses. They were the people who did a lot of the hard work, but the really hard work was organizing the communities to be there when we left, because they were going to be there one way or another, and it's better if they were organized.
John, you spent about 25 or 30 years building organizations that help organizations. What's your take coming on the end of that observation by Gerald?
So I guess there's a few things. One, going back to your earlier question, Jack, you know, I think I would not clip the wings of students who believe they could change the world. So calling something grandiose is already prejudicing one against it. You know, we have to have work at multiple levels. I can tell you, we at the Othering and Belonging Institute, my staff and others, we produce a lot of the materials for the runoff in January in the Georgia Senate elections. And I literally had people come to me because we, you know, just won the November election. It's like, okay, now this is a long shot. You know, you're kind of wasting your time, really. You might get one, but you're not going to get two. And my response to them was that it might be a long shot, but we have Steph Curry on our team. And as they say, every shot you don't take, you miss. And so the world is changing really fast. And I think that the sort of incrementalism that was in favor in the 80s and 90s has to be rethought. You know, Gerald, I hope you're safe in Austin if you are in Austin. But you know,
I'm in New Haven and I'm safe.
Oh, good.
You can look in the background; it's all just green trees.
You know, the fires in California. I mean, I don't think we have time. Yes, we have to work at multiple levels, and we certainly don't want to be parachuting in. So we have to work. I mean, when we do our work now, we work very deeply with organizers, with activists, but also with cities. So we have to have an infrastructure. But that infrastructure gives us the capacity to think even bigger, not smaller. And so I think the right relationships and the right strategies, but also understanding that the changes that produce. At the beginning of the 2000, there were only a couple of authoritarian countries, and we thought democracy was on the ascendance. And yes, there was China, but the world was basically moving to democracy. Now, most of the world lives under authoritarian leader in less than 20 years. So something's happening, and I don't think we have the luxury to say, you know, I'll just bury my head and do what I can do because that's what I can do. It's like put your arms in arms with other people, and people will work at different levels. So that would be and as you said, Jack, I've started a dozen different organizations, and most of them are still happening and making an impact. Let's give you one last example. There were a group of us in the 90s that wanted to do two things. We wanted to bring the concept of equity into the public discourse. And if you go back, and it's Angela Blackwell, Manuel Pastor, and myself, it wasn't there. We actually wanted to insert that into the public lexicon. The other one was structural racism. There were a group of about 15 of us that met for 2 years trying to figure out how to move people off of individualized expressions of racism and think about structures. Now, and both of those things happen. Now, we lost control of them, so people interpret them in ways that we didn't mean. But it's been, looking back, it's kind of amazing that those things have happened. And then the last one, of course, is implicit bias. Again, I was at the fountainhead of that, of trying to get that research out into the public discourse. It's out. So I wouldn't clip people's feathers, but just say, be concerned with who's in your flock.
No, I largely did that sort of as self-mocking, thinking of myself as at 25, saying we can, by golly, take this. But you're right. Of course, people should think big. You're making the argument implicitly there also that cultural reform is critical, and cultural reform that really goes to things as basic as the language that's used and the framing that comes up. And maybe we're at the point now where some of that reframing can happen. And Gerald, it's the younger people you're talking about are thinking in a different, some of them in different ways than people might have 30 years ago. Kimberly, when you were off the call, when we were doing the planning call, we said, and I think we told you about it, that you're the only person on the call that's not yet eligible for a COVID shot, because you're the only person young enough, not to be in one of those special categories. Do you have a different take than this group of, senior citizens that and wannabe senior citizens who are, having this part of the conversation?
So actually, I agree with what John and both what Gerald just said. So first, this idea of dreaming big, so I definitely, in my work, as I have written about a federal right to education and sort of the need to ensure each child gets an excellent education, I often have had people say, like, what you're asking for is impossible. It's never going to happen. And that we're never going to get to where we distribute, a high quality education to every child. And so I've had that said to me multiple times in my work, that it's, it's too sort of pie in the sky. And I disagree. I think that we are, our nation is clearly built on the backs of what is now a broken education system, but I don't think it has to be that way. And I think, one of the things that the founder for Teach, I don't want to debate Teach for America, but the founder, Wendy Kopp, talks about is kind of having students go into the classrooms so that they know how broken the system is, and then go out and help to be reformed. So you have people from Teach for America who are, state education chiefs now, and who are in positions of power. And so this idea that you keep, informing each generation, keep getting new people, get what I could tell my students, boots on the ground. Like, all my students are boots on the ground. I am preparing you to go out and help topple this system. And so that is part of what I aim to do. But I think it's also really important for particularly the young people on the call to hear what Gerald said, which is you must have a grassroots movement that accompanies litigation. One of the reasons that school finance litigation has been less successful than it could have been is because in the places where you get a ruling, you don't always have a broad coalition of people who are going to sustain the reforms and to sustain the pressure on the legislature. And so what you get is rulings that, it goes a long time back and forth between the court and the legislature, and the legislature finally does something. Then you'll get, a recession or something else, and they'll start to draw back. And you have to have that grassroots support who remembers the fight that it took to get where you get the victory, and then is willing to keep pushing it forward. So you have to be relentless on all these things, whether it's white supremacy, school funding litigation, any of it. And I think that is definitely an important lesson, because too often litigators sort of pile it in, bring the litigation and then pick up their briefcase and their computer and leave. And I think that's part of the reason we have not had the success that we could have had with school funding litigation, is not enough grassroots organizing to sustain the wins that have occurred.
I have a question that somebody has put into the question and answer box that probably is for anybody, but probably mainly for you, Kimberly. Do you think programs such as abolitionist teaching and social justice education are good starting points for educators. And what recommendations would you offer to elementary and high school educators and officials about how to move forward in this, maybe for all the rest of it?
Yeah, I can start with that. So I think, definitely sort of rethinking the curriculum and what we teach our children about history, and from slavery through the Civil War to Jim Crow, like having a more accurate and holistic understanding of history is essential to changing where our nation is going. I mean, it's even as simple as one thing I discovered as as we were raising our kids is that maps are not drafted to scale. Africa is shrunk on most maps. And if you look at an accurate map, Africa is much larger, for example, than Europe, right? So these things, the map, the globe in most classrooms is inaccurate to scale, right? That's a problem. It underestimates people of color and their place in history. And so there's just so much that needs to be corrected in what we teach our children. I was really excited last week when I had met with our child's 4th grade teacher about teaching slavery. And I said, I just want to make sure that this is done thoughtfully and in a way that's empowering, particularly for our child, but for all the children, that you understand it accurately. And, she talked with them about calling them enslaved people instead of slavery and the importance of that nomenclature, right? That's a step forward. That is a step forward in identifying, how we think about who was doing the labor on which this country was built. They weren't not slaves. They were people who were subject to slavery. And so I just think there's so much that educators can do. They don't have to, you don't have to be a lawyer to help change and topple the system. Teachers shape the narrative every day. And so they are certainly, I don't want to endorse any one type of curriculum or teaching, but I think teaching that empowers people with knowledge to understand our history accurately and helps kids understand how they can be agents of change is really, really essential.
I want to do something that actually starts us toward a close by inviting each of the 4 of you in turn to offer some concluding thoughts, 4 or 5, 6 minutes, about the way forward for a broader equal protection that may in part reiterate some of the points you've made previously, but consolidate them. Or else respond to something that you've heard during the course of this discussion. And if we do that, I think we'll be shortly after 3 o'clock, 3:05, and we could close up at that point. Is there someone who'd like to be a first person with this new assignment that I just recommended for us all?
Well, I'll start. I'm not sure I have 5 minutes to say. I would reiterate a theme that's been articulated more by others than by me, that the way forward on an equality agenda starts locally with organization and mobilization of activists around locally important issues, then addressing them through voting mobilizations, both at the local and at the state levels. But in addition, because we are observing significant efforts to both interfere with people's ability to vote straightforwardly or to influence policy making at the local level, we have to pay attention to advancing what I guess is being called the democracy or equality agenda in Congress, pushing for the adoption of I think, pretty aggressive voter protection or anti-vote suppression legislation at the national level is really important. I was this morning looking at CNN on my computer, and our third or fourth items are Georgia legislators' efforts at voter suppression said to target Black voters. And the next one was Governor DeSantis of Florida urges legislatures to restrict voting. Now, something has to be done to stop that. And given the composition of the legislatures now in those states, the only way to do something is to do something on the national level. And then I want to stress, worry about what the Supreme Court is going to do. One of the lessons of actually starting out with a limited focus on, in my case, the school desegregation litigation in the 1930s and 40s. One of the lessons of that was that you have to pay attention to the entire playing field. It's not just where you are now that matters, because you do something over here and somewhere over there, somebody can do something that will mess things up for you. And you have to figure out overall what the big picture is going to be. Now, you can't work, no individual can work on all of the things that need to be worked on. But people who are interested in promoting equality have to make sure that their efforts are directed at the range of institutions that are important.
Very wise. Who wants to follow those wise remarks? Kimberly, you're smiling. I'm afraid, it's like in a class, so you shouldn't have moved.
Oh, I can go. That's fine. So, sort of building off of those remarks, I think it's important that we take the fight for high quality education for all children and equity in education, that we engage in that fight at all levels. So my work has focused on equitable right to education, but I've also written about education as a civil right, which can be advanced at the state level and the local level. Yes, we want to get legislation out of Congress. That is definitely the ultimate goal, but there are important reforms that can happen in states and even in districts to protect children's right to access education and to do important things such as integrate schools along lines of race and class in ways that decouple educational opportunity in race and class. Right now, a child's race and class often very much influence the opportunities they get, but it does not have to be that way. And so the states still have, the lion's share of authority in education. And so it's important to understand that at all levels, this issue can be championed and advanced. And so, I think for those who might be skeptical that we will get a federal right to education, that's okay. You can work on the issue at the state level and you can work on the issue at the local level. And so I think it's important that we sort of have all hands on deck and work on this in multiple ways. I think the other thing to just take away from this, I've learned a lot from my panelists as always. This reminded me a little bit of being back in law school, I will say. I enjoyed listening to my panelists and all they had to say. And I think that as we think about sort of where we head, I think we have to really think about who's in our courts. So I agree completely with what Mark said, that the courts have had a worse record on advancing equality. And one of the things that the conservative agenda has prioritized is placing judges in federal courts. And the Democrats have not prioritized that in the same way. Unfortunately, even when we had President Obama and congressional control, we did not get the number of judges who were young and progressive into judgeships. And so I think if we want to advance this agenda, and we want the courts to be part of advancing that, then I think we have to, those who are focused on a more progressive agenda have to prioritize the courts as part of that. We don't want them to continue this trajectory of reducing equality. And I think that's something too often we're not focused on it in the same way. Getting Amy Coney Barrett onto the Supreme Court has been the goal of many in the conservative movement since Roe v. Wade. Like they played the long game. They went long, they went hard, and they just kept at it until they got it, right? And so I think we have to be in it in that same relentless long game way of we've got to have the judges, young and on the court and in the district courts and the appellate courts and ultimately on the Supreme Court, right? So I think those are things to think about, is that, the roots of what we're trying to dismantle, white supremacy, racism, inequality, classism, are deep and far and wide in our nation. And I think we just have to remember to be as relentless in dismantling them as people have been and continue to be in having those things have a hold on our nation.
Thank you. Gerald, John?
I can go and I let John back clean up. How about that? Is that okay?
All right.
Yeah, I'll just be brief. I mean, one of the things that came out of the discussion today is to remember that the Constitution and the 14th Amendment applies to all branches of government, right? So you can think of it as court doctrine, but the ethos, as well as the practical meaning of the 14th Amendment, applies to the president, it applies to the administrative agencies, it applies to the Congress, it applies to everyone as they think about how they have to produce the country or the elements that will help us create the country that we want. I think we ought to have, like we're having today, but in many other fora, discussions about what we imagine the 14th Amendment to mean. I think John's invocation of the new birth of freedom, right, is actually a really good invocation, and we should remind ourselves of that. I think we do have to be relentless in protecting and expanding voting opportunities, just as the people are going to be relentless in restricting voting, trying to restrict voting opportunities. We have to struggle for it. And then the point, if I can expand Kimberly's point just a little bit, it's important for us to think about what are the things that are necessary to enable full participation, right? If in fact what we really want is a functioning representative democracy, then what we have to do is we have to create a capacity for people to fully participate. Education is part of it. Employment is part of it. Housing is part of it. The kinds of things that progressive groups have struggled for as long as I've been alive, right, are all actually constituent elements of the things that are necessary to be a full participant. And I think that we have to just work on that. And I guess I'll just leave it there. But there's work to be done. I think there's reason to be hopeful, but there's also reason to recognize that the hope will come by putting our shoulder to the wheel.
Amen. John.
So just to add a few things, I do think things will change. I mean, it's interesting to me. I agree with Kimberly and Gerald and Mark. But if you look at the Trump administration, I'm not saying they should be our touchstone, but they had no respect for institutions, no respect for norms, no respect for the Constitution. They had an agenda, and it was a pretty negative agenda. But they were willing to go all the way to storming Congress and to get their way, and to get Amy on the court. I mean, Mitch McConnell, after stopping Garland because the election was coming, was like, that was then, this is now. So I guess what I'm saying is I think we have to, we're not just sort of operating within institutions, we're actually making institutions. And so I think it was Mark's point in terms of, and I'm not saying whatever, but when Roosevelt threatened to pack the court rather than watch his agenda go down in flames, I think we have to be willing to put that on the table. Yes, use the courts, but just the threat, and Roosevelt didn't do it, right? The threat actually caused the court to shift. The court is made up, it's a political animal. It can't be having a veto over the kind of society we want. But also I want to pick up, first of all, agreeing with Gerald and Kimberly in terms of having the community involved. So Jack, I think you were involved in the Sheff versus O'Neill, which is still going on because it was an adequacy case and the community was involved. And I think that was the way to do the cases. That was 30 years ago, I don't know, a long time ago, I don't know, that we were all involved in that case. When I think about the 10% plan and from afar, and maybe, Cheryl, you have a little from afar too, being in New Haven, probably stuck at Yale. From afar, one of the ways that the 10% plan worked, two things. One, it was cross-racial and also cross-geography. And so when the Texas legislature tried to dismantle it, you had a coalition. So we have to be smart. So sometimes we build our strategies with a narrow band, and it makes them unstable. So we have to be willing to actually broaden that. And then finally, I'd say we have to think about a future for all and how to get there. And education plays a role, but it's not enough. And how do we imagine a future for all? And what the right wing is saying is there is no future for all. So we need to exclude some people. We need to build walls. We need to build cages. We need to build, because y'all folks are a threat to any future that I want to have. So we have to actually be very clear that we're trying to build a future for all and for the planet itself, and be very dogged about that, but also be very clear about it.
It was a great pleasure to moderate a panel with people whom I so respect and admire for the work they've done in the past and the work I suspect they're going to continue to do in the present and the future. And you're a wonderful group to have closed out this conference on the way forward, because you're going to be part of the way forward, I suspect, as long as you draw breath. And we hope that's a long, long time. So thank you very much. And